No.
May I please, your lordship? Lordship, with the consent from the other side, I beg to mention item number 8. Yeah, the conducting council is out of station, lordship. This matter will be taken after 2 weeks.
Have you given your sleep?
Lordship, it was holiday. That's why we were not able to give. lordship.
All excuses.
Morning he told me, but morning he told me.
So you've given your consent?
Morning I said yes.
Okay. On request made on behalf of Mr.
As does lordship.
No, you are making
NNB Chaudhary.
NNB Chowdhury, then the counsel for the applicants. When do you want?
After 2 weeks, lordship.
List the matter after 2 weeks.
Much obliged.
May it please your lordship,
Yeah.
the lordship beg to mention item number 9.
Oh.
My senior Mr. K. Goswami, senior advocate, was appointed as amicus for this case.
Oh.
However, he's out of station, your lordship.
Have you taken the consent?
Uh,
Morning he informed that, sir. Mr. Goswami is in Calcutta. I have no.
Okay, on request made on behalf of Mr. K. Goswami, then the amicus curiae. List the matter after
uh,
2 weeks.
Item 1 of daily list, admission.
Jail appeal for the first time has come up.
This is an appeal from jail. Admits. Call for the reports. MS John, Leonard additional people. Appears on behalf of the state of Assam. Is directed to appoint an amicus curiae from the impaneled list. Did I say call for the LCS? List after 4 weeks.
Item 2, order.
This is a leave petition preferred by the state of Assam, but
Lordship, may I pray for adjourning the matter for the day, Lordship? The engaged counsel, Mr. Gautam Chaudhary, is out of station, Lordship. He has informed me over telephone to seek adjournment, Lordship.
earlier the delay.
Gautam Chaudhary, Lordship.
G. Chaudhary. He is appearing for both the respondents.
Mm.
In fact, earlier the condonation delay application was condoned. The delay was condoned. Today it has come up for leave. Anyway, whenever he comes back.
Khatam S. Jahan, Leonard additional PP for the applicant. On request made on behalf of Mr. G. Chaudhary, Leonard counsel for respondent 1 and 2. List the matter after 2 weeks.
Obliged.
3,
Three.
My lord, the bail application for and the lower court records has come.
It has come.
It has come.
I filed my objection also to the IA.
Where?
In the IA, I had filed it. I hope it's there in the
Yes,
records.
it's the,
188 of 23.
yes.
So my lord, in this case, if your lordship goes to page 44 of my paper book, my lord.
Of the paper book.
Yeah,
Where's the paper book?
paper book means my petition, my lord. Petition. Main petition, my lord.
Oh,
44. I have given a cert.
1 minute.
I have given a cert. So your lordship will,
Yes.
yes, date of offense 15/10/2017, date of affair 16/10/17, date of charge sheet 31/10/17, date of framing charge 12/3/18, then date of commencement of the evidence 24/18, date on which the judgment is received and 27/1/23, and last date of sentencing order, if any, 7/2/23. That is the, and in the smaller version, your lordship will see he was after the charge, he was for 60 days in the custody. Last column, my lord. Period of detention, we have made it 60 days. Then after that, my lord, he has been granted bail. Accused number 1, he was granted bail on 16/12/17. The first, my lord,
Yes.
yes. And that means, my lord, from 17 to 23, about 6 years, he has been bailed during the trial. So in those, there is nothing against him, my lord, during these 6 years. And he's 75 years old man and also a diseased person. And my lord, the Honorable Trial Court, the prosecution projected that there are 3 eyewitnesses. In fact, there is no eyewitnesses. And my learned friend also, in her objection, in para 4, in para 4, my lord, in her objection, para 4, Roman 2. Roman 2. You like to got it? Para 4, Roman 2. The most clinching evidence in the instant case is the testimony of PW3. And he has been shown as the eyewitness. 3, 5, PW6. These are alleged to be the eyewitness. And I would try to show your lordship that from the judgment itself, my lord.
Where's the judgment?
Judgment is at page 66, your lordship. The relevant portion is at 60. It put a judgment will be. What will you want from it? Decide. It's 52, 50. What about page 50? Page 50, your lordship will find para 17.
Page?
Page 50, 50, para 17.
Yes.
Yes, para PW3, Hemanta Soikia has deposed that the occurrence took place on 15/10/27 at 10 p.m. in the house of complainant. Complainant is his aunt, and at that time he was at complainant house. Prasanto Setia was standing at the veranda of the shop. He is the disease, my lord. He, along with complainant and his relatives, brother Rahul Soikia, were standing at the veranda of the house of the complainant. The accused, Kamal Dihinga, brought one hammer and assaulted Prasanto Setia on the backside of his head. The accused, Kamal Dihinga, assaulted Prasanto Setia third time with a hammer on the head. Prasanto Setia, holding his hand, he went towards the roadside. The complainant also ran along with Prasanto Setia. Immediately, family members of Kamal Dihingia came to the place of occurrence and being scared, two minor relatives, Vicky and Rahul, got scared and came inside the house. The family members of the accused Kamal Dihingia tried to break open the main door of the accused, which was closed, bolted by the occupants of inside. By kicking it, tried to scare them and breaking the door. The family members of the accused person, Kamal Dihingia, stayed outside the house of the complainant for about 25 minutes. Later, he came to know Prafullo Hazarika, that Prasanto Setia, with his head injury, ran to the house of Prafullo Hazarika, who took him to the vehicle to the Borbora police station, and from Borbora PS, the victim, Prasanto Setia, was shifted to the Borbora hospital for treatment. From there, Prasanto Setia was shifted to AMC Dibrugarh, and from there, Aditya Hospital, where he died after 1 day treatment. During the cross-examination, he stated that he came to the house of complainant as he was informed that the husband of the complainant was suffering from fever. He stated that the house of the complainant is a two-story building. At that time of occurrence, they were standing on the veranda of the ground floor of the house of the complainant. He had stated before police that at the time he was standing in the first floor of the house of the complainant. He denied the suggestion that he deposed before the police that on the date of occurrence, he, along with his other two brothers, were drunk and had challenged who can jump from the first floor of the house to the complainant. He denied the suggestion that before the police that Bipul Dihingia and Vikas did not assault Prasanto Dihingia, Prasanto Setia. These were also two, my lord, accused person. He stated that the house of accused Bipul Dihingia and Prasanto Setia were attached boundary. He heard that there was a dispute going on between Prasanto Setia and Bipul Dihingia. He denied the suggestion that Prasanto Setia sitting with them on the second floor of the house. He denied the suggestion that as they were drunk and they were betting to jump from second floor of the house, and accordingly Prasanto Dihingia fell from the second floor of the house and sustained injury. He denied the suggestion that he had stated before the police that Kamal Dihingia was carrying hammer on his hand. He stated that he know that a case has been filed against them by the wife of Bipul Dihingia. He stated that at the particular time Rahul and Vicky were present. He stated that he had not seen any occurrence himself, and the disease were not hit with a hammer by the accused Kamal Dihingia. This is important, my lord. He has not seen the incident by himself, although the prosecution tried to project him as a eyewitness. Then Putul Soikia, he was also PW4, he was also projected as eyewitness. Then page 53. The last few lines from the bottom, my lord. The victim, Prasanto Setia, succumbed to the injury on 17/0/27 at about 1 p.m. on 16/10/17 when he had gone to Borbora PS, and SI Sutia had shown him the hammer by which the disease was assaulted and seized. He proved the seizure exhibit 2. During the cross-examination, he stated that he had not seen the occurrence. The first line, my lord. He did not remember it. So, my lord, he is also not an eyewitness. He has not seen it by his own eye. That 54. It is very important, my lord. The hammer, which was 54 first line, which was seized by Borborua police, handed over by daughter-in-law of accused Kamal Dihingia to the police. So Kamal Dihingia, he is the, my lord, the accused person, main person. He is in jail now. But hammer was not with him. Hammer was with his daughter-in-law. That means the son is also a accused. So here, my lord, it is not clear whether the person, accused number 5, his son, he has used the hammer or he, because hammer was not with him. Hammer was with the daughter of the accused, daughter-in-law of the accused. So these are some of the main, my lord, discrepancies, and the honorable court also. The PW 5, para 19, my lord. Sri Alpit Kaur had deposed that the incident took place on Iman at so-and-so house of the deceased person. He was there with his brother Simanta Soikia, Rahul Soikia, and the deceased. He and Rahul Soikia were standing on the top of the floor of the house, and Simanto and his uncle, since deceased, on the ground floor. The accused Bipul Dihingia came with a iron rod, destroyed the bamboo fencing and of the house and complainant. But after that, the accused Bipul Dihingia assaulted Simanta Soikia. See, my lord, this is important. This Bipul Dihingia is the son. He also beat Simanta Soikia. The complainant opened an iron gate present in the house, so they came and stood before the gate. Then, my lord, the deceased persons were along with the family members and attached with this. The wife of accused Dilip Dihingia, Bipul Dihingia, called Kamal Dihingia over phone to the place of occurrence. Accordingly, he arrived at the place of occurrence. The accused Kamal Dihingia brought a hammer. At the time, Prasanto Setia, since Didi was sitting in front of the shop of the complainant, the accused Kamal came there and assaulted Prasanto Dihingia, since Didi with help of a martul, that is a hammer, on the back. Therefore, Prasanto Dihingia, since Didi pulled his head, ran to the neighbor's house. He complainant also. The accused person also tried to assault him again. Thereafter, they entered into their house. Then, my lord, in the cross, your lordship will find. Then, in the cross, my lord, your lordship will can skip and go to page 57. In the however, Orbit Core fade away. Page 57.
Yes.
The Orbit, he did not see, he has played away from the scene. And the same thing has been said by Rahul Soikia in his deposition. Rahul Soikia, PW6. He played away. He is not a eyewitness in this case. Now, the honorable court below at page 66 the Lordship will see, both PW5 and PW6 stated in their evidence that accused, this is the version of the court, honorable court, accused A3 came to the place of occurrence by breaking upon the bamboo fence and assaulted Simanta Saikia when when Prasanto Setia, since the deed intervened, accused number 3 started quarreling with Prasanto Setia, on which he fell down. So five had a quarrel with the disease, and he fell down. So this is not taken into account by learned court below, that he also beat the victim, maybe two versions. One is by martel and another by rod. So who has given the fatal, that is not determined by the learned court below. Then the same thing has been stated in paragraphs in page 67, para 3. It is established that accused person A3 quarrel with Prasanto Setia. Now A3 has been acquitted in the first day since the deed and made him fall through. There is no evidence of any injury in the said fall. It is further established that accused A2 and A3 had scuffled with Rahul Saikia and Simanta Saikia respectively. Then, my lord, next paragraph, act of injuries committed by accused A1.
Next,
Page 67, para C. Para C. It starts like this, my lord. Roman 1. PWT had categorically stated that accused A1 had brought one hammer and assaulted Prasanto Setia on the backside of the head, but he is not an eyewitness. Thereupon, Prasanto Setia ran towards the road, holding his head. During cross-examination, the witness PW3 has denied suggestion to the effect that the head injury caused to the Prasanto is due to fall from the second floor of terrace. Witness had withstood the meticulous cross-examination by the defense. Learned counsel of the defense submitted that the last sentence of the evidence of PW3 demolishes the entire evidence of PW3. He said that sentence of the cross-examination PW3 reads as follows. I have not seen any occurrence myself, and the disease was not hit by a hammer by the accused Komal Dihingia. So this ends PW3, which was projected as a reliable evidence. He himself says that I have not seen. And I have not seen the disease was not murdered. He also became a hearsay evidence man. Now, the Honorable Court also said like this, my lord. Read the entire evidence of PW3 holistically. It appears that this said last sentence was suggestion put to the witness PW3, but some in italics, which is that was italics, my lord. Common above was not recorded in the form of suggestion. Be that as it may, the benefit of these two go to the accused person. Accordingly, the evidence of PW3 that accused A1 assaulted Prasanto Saikia with hammer cannot be relied upon by this court. So there is the person who has been projected as eyewitness. He says that he was not there.
about the next three paragraphs?
Yes. to, come on.
Yeah,
Hmm.
they have-
No, no. Be that as it may, there are benefit of the rest. PW5, in his evidence, stated that upon being called by the wife of accused A3, accused A1 came to the place of occurrence and brought one hammer and assaulted Prasanto Setia on his back with his hammer. It is also stated by PW5 that upon receipt of injury, Prasanto Setia went to the neighbor's house holding backside of his head. In the evidence of PW6 also stated that accused A1 came to the backside with an iron hammer and hit thrice to the back of the diseased Prasanto Setia. Being injured, Prasanto Setia held his head and fled to the neighbor's house. PW2 was categorically stated in his evidence that he was the neighbor of Prasanto Hazeka, and on that night of occurrence in his house shouting, brother, I am dead, I am dead. And that at that time, blood was oozing from his head, and he gave gamusha to cover his own. There is no rebuttal to the above evidence of 5, 6, and PW2, either by the cross-examination or reading of the evidence. PW5 and 6, it will 6 categorically stated that this is Prasanto sustained a head injury which was caused by blunt force. Impact cannot be caused by fall. Defense has tried to thrust upon the point, and the hammer was never seized from the accused A1. Even same was not been proved before the court for Caesar witness. And thus, in absence of weapon of offense, it cannot be held that Prasanto Setia was hit in his head by the hammer. In the opinion of this court, non-proving the hammer before the court does not vitiate the prosecution case. The fall that injury was caused by the blunt force, impact of the impact on record and prove that medical evidence. And there is already the evidence of the witnesses that injury was caused by iron hammer. So my lord, this is basic thing. The weapon should have been exhibited, and that weapon should have been sent to the forensic laboratory if it was any blood stain or fingerprint in that particular weapon. And to remove the doubt that that was the weapon which was used for killing, for that, my lord, sustaining injury to the head.
But PW5 was played away. All bit cross played away.
What is it?
All bit cross played away. Yeah,
Case हुआ है. This is a dangerous proposition by the lower court. I am humble. And then he also tried to project a confessional statement, which is, according to the prosecution, has said to the police. And there was no eyewitness to that. Your Lordship will, in the same page 69, para 5-7, para 7, last para, my lord. Moreover, the aforesaid evidence of paragraph PW 5 and 6 is also corroborated by the evidence of PW 8 IO. In his evidence, PW 8 stated that upon coming to know that Prasanto Setia is undergoing treatment in the hospital, he went to the hospital and recorded his statement. Prasanto Setia stated him that while he was sitting on the step of veranda of the house, accused A1 came and hit him with an iron hammer on his head. Apparently, this said statement of Prasanto Setia, since disease, cannot be termed as dying declaration. This is held by the Honorable Court himself. However, the said statement of PW cannot be just brushed aside and as unbelievable simply because he is coming from IO of the case. This is coming from the IO of the case. It is settled law of evidence of IO. If does not suffer any infirmity on the doubt cannot be discarded. Public servant must be presumed to be act honest. These are, my lord, his own, my lord, to say. Evidence Act clearly says anything said before the police is not admissible. If no punishment can be inflicted on that, my lord. This is his honorable judge's own, my lord, reasoning. Then he said so many things about the society that if this is at page 71, your lordship will see. This court is of the view that the aforesaid submission of learned counsel for the defense is misplaced and devoid of any merit. FIR only sets the criminal law in motion. FIR is not a substantial piece of evidence. It is used only to corroborate the contradiction the maker. It cannot be used for corroborate of contradict any other witnesses. Now, my lord, it would just is it that Harry could say the PW1 to discard with the perfect.
Page 47, page 47. There are 9.
At this moment, my lord, I will try to take page 47.
Yes.
Cannot be relied upon. Cannot be relied upon.
No, no, was the which is it?
The outstate of the submission of the PW1 cannot be relied in the present case. Page 48.
My lord, you will also kindly see page 48. First, para 10, it says, on the other hand, learned additional PP of the state has submitted that evidence of 3 eyewitnesses, PW 3, 5, and 6, clearly establish the case of the prosecution. These are not eyewitnesses, he says that eyewitness, beyond all reasonable doubts, and their evidence are corroborated with each other. So far, the mismatching of in evidence of PW1 is concerned. Learned PP had agreed to the submission of the learned defense counsel that there is some anomaly in the evidence of PW1. At the outset, let me address the submission of the learned counsel for the accused person that evidence of PW1 cannot be relied in the present case. She is the wife of the deceased, and
So these are practically he's reporting the submissions made by the. additional
my lord. And he says that I have perused the evidence of PW1, other evidence meticulously from the plain reading of PW1. It is transpires that there is a major ambiguity anomaly in her cross-examination. A part of the cross-examination of PW1 is not at all matching with the cross-examination in C. It appears that the said part of the cross-examination of PW is of some other witnesses, most probably a PWT, but these things are not cannot be taken into in the criminal case to convict a person. In that thereafter, in view of the aforesaid anomaly and ambiguity in the evidence of prosecution of PW1, the informant, this court deems it fit to accept the prayer of the learned counsel for of the accused person, the evidence of PW1 informant cannot be relied upon for the purpose of determining the point involved in the present case. So Honorable Court has himself discarded the evidence of PW1. So under all these circumstances matter, it is a fit case of where the accused will be released. And therefore, my humble prayer is that although he was tried, he should, and considering his age of 75 years, and he's a diseased person, I will pray your lordship that if he's put into the custody, that will be a futile exercise on the part of the prosecution, and he will unnecessarily bear the my lord, and he will be ultimately he will be released. And in such cases, also he was for bail for about 6 years after during a trial, and there is nothing against him. Every time he went to the court when the court has summoned him, and he has abided by all the instruction of the court. So my humble prayer before lordship that he should be released on bail. That's my humble thanks.
As far as the age and the disease is concerned,
My lord.
there I have my objection. Age cannot be a factor, Honorable Supreme Court has said. And the disease and the illness part, I had in fact brought a report.
My lord, I will leave that to your lordship consideration. Only I have said that he is a man diseased, and that is indicated in the report. And he has been, as your lordship has
No, what do you mean? What disease?
disease, he has kidney trouble
Okay.
and some.
But on the last occasion, I got a report from the jail superintendent, the doctor of the jail.
Yes, yes. ma'am.
And he
After
gave us a
that,
report. That he simply had some weakness problem. And I remember it must be in the record, and lordship, it was not serious, and lordship did not go into.
yes,
He had back pain and he had some generalized body weakness. He was examined,
that is correct.
he was given treatment, he was taken to Assam Medical College Hospital.
Yes,
There also he was given treatment. About kidneys,
But,
kidney problem and all those are not there.
That is
Only
correct.
general weakness.
that is correct.
So as far as medical issues are concerned, lordship had not gone into, and
my lord.
lordship has accepted the report.
Anyway, that was my submission before your lordship.
Ah.
That he is a ailing person and an old man, and ultimately he will be released because there is no concrete eyewitness against him, and there are some other the honorable court below has set up and said that they are eyewitness, and he himself has also admitted, honorable court, that they are not eyewitness. So when there is no eyewitness, my lord, ultimately he will have to be released on the final hearing. So my humble prayer before your lordship that your lordship may consider him to release on bail.
As far as merit is concerned, even if we brush aside 1, 2, 3, 4, PW1, of course, when she heard hue and cry, she was sleeping, she came out and she saw her husband lying injured. Okay, we can accept that she had not
Yes,
seen
ma'am.
the occurrence. 2,
That is correct,
there is nothing.
But the honorable high
If
court
he's-
has, honorable
Say he can.
trial court himself has said.
Just a minute.
My lord.
He can reply later. And then PW3, of course, in the cross-examination, he said, in what context he said that I had not seen the actual occurrence. We will go through during the time of hearing. Otherwise, in the examination in chief, he was present in the veranda and he saw the incident. That is what he had said.
When he has not seen my.
4 also, he in the cross-examination, he said I had not seen. But we have PW number 5 and 6. 5 and 6, I don't see, of course, subject to correction, that he had resigned from the statement given during the examination in chief. Because PW 5 said, initially there was a ruckus created by Bipul Dihingia. He came inside the house, he was inside the compound, and the PW 5 was there on the top floor. And then he saw him coming inside the compound, creating a ruckus, challenging people, whoever was there. And then he came downstairs. Deceased and one Simonto and my uncle was there. Yes, they were there in the ground floor. Simonto and his uncle were there in the ground floor. He and Rahul Saikia was on the top floor. When he saw Bipul Dihingia doing all this, he came downstairs. He was standing on the road. There he saw Bipul Dihingia initially created all this. He assaulted few. Thereafter, wife of Bipul Dihingia called Kamal Dihingia. Out of nowhere, he came with a hammer. And he had given the hits on the 3 times hit on the accused, on the deceased. This is there in PW5 statement. I can read it out, it's there. And in the cross-examination, I'll read his cross. The deceased and the accused persons are relative. I do not know if any land dispute was there. We were there at the roof of the first floor. At that time, we are the 5 members in the house. The shop of my uncle was open. Police recorded my statement, but I did not state before police that on that day in the evening, we were on the roof. That is not required, it can be an omission. It is not a fact, I did not state before police that on the day of incident, Bipul Dihingia came and was shouting. It is not a fact that Bipul Dihingia have warned us to play on top of the roof. It is not a fact, I did not state that Bipul's wife called Kamal Dihingia over phone. It is not a fact, today I have deposed evidence as tutored. It is not a fact that Kamal Dihingia, it is not a fact that on that day Kamal Dihingia came to the alleged place of occurrence. It is not a fact that by standing on the roof of the house, the ground portion is not visible. It is not a fact while we were having fun at the roof, he fell down. The actual quarrel took place. So nowhere in his cross-examination, his deposition in the examination chief was shattered or demolished. 5 stands as it is. He seems to be the eyewitness. 6 also. 6 is Rahul Saikia. He was also there. On the day of incident, I was at the house of the deceased. I was accompanied with my friends, PW5 also. And at that time, uncle was bedridden because the deceased was not well. And people had come to take him to the hospital. And then the incident took place at the night. And on the day of incident, after having our dinner, we were at the terrace, but my aunt being oblivious to this, closed the grill of the terrace. When we could not open the grill, Simonto Saikia mocked at us and wished us if we could jump from the terrace, he would give us 500 rupees. On this, accused Bipul Dihingia hearing upon the mocking, full rage and all, he entered the compound with a big bamboo. At that time, Prasanto and Simonto were sitting on the stairs. Bipul came and strangled Simonto. So Bipul came and he was assaulting the rest of the persons. And then a few lines from there, accused Kamal Dihingia out of nowhere came from the backside with an iron hammer and hit thrice on the head of my uncle. My uncle being injured, pothole. So he in his examination in chief, he had said this. He was there, very much present. And then in his cross-examination, the statements are not demolished. Nowhere I see. It is not a fact that I have not stated in all those suggestions he has denied. And again, he had reiterated, accused Kamal Dihingia came to the place of occurrence 10 minutes after Bipul and party went away. And then it is not a fact that Kamal Dihingia, as alleged, had not assaulted my deceased uncle. Rather, my uncle has died. So 5 and 6, they are the eyewitness, even if you brush aside 1, 2, 3, 4. So they had seen him assaulting thrice. After Bipul Dihingia and other people left, wife called him over, wife of Bipul Dihingia called him over telephone. He came and he assaulted. Of course, dying declaration, okay, it was not written by the police. We may not go into. Had he written it, then it would have become a dying declaration. Of course, the requirement, why he did not get it recorded by doctor or the magistrate, that will come. But dying declaration, I'm not pressing on. But 5 and 6 are the eyewitnesses who have seen the occurrence. Age and disease, illness factor is not there. So I would pray that this is not a case for bail. Lordship can hear the entire matter in a short span of time. This is, I think, 2022 matter. And this is, of course, 23 matter. This will come in its own course. This is not a case of bail when people have seen it. This is a humble form.
My lord, may I submit one thing, my lord?
Yes.
My lord, one last submission, my lord. The occurrence took place at 10:30 in the night. And this is a village area where there is no provisions for better street light and everything. Now, my lord, the honorable court
It
below,
was a concrete building, isn't it?
anyway, it was
It was a
in you
concrete building with a
under construction,
two-story
under
building.
construction.
Two-story building perhaps.
Obviously, there would have been
if-
lights.
If my lord, one is in the top floor, these persons, and this from there, it may not be visible in the ground floor what happened. And there are
That's suggestion,
so many
yes.
people. Your lordship will kindly go to page 90. Page 90.
Yes.
First line, my lord. Neighbors, namely Prasanto Setia. And after hearing the hue and cry, her husband Bipul Dihingia went to the house of Prasanto Setia and requested him not to make a noise and disturbance. Then Prasanto Setia, going with the accused Simanto Soikia, Rahul Soikia, and some other, started assault her husband with a lathi and rod. So this aspect that there is involvement of rod and lathis, and this has not been taken account by the learned court. Only hammer. And it is not. And in page 57 also your lordship will find middle part, my lord. The question of PW6. He says, however, Orchid core fade away. PW6 para 20.
Where?
Para 57, my lord. Oh, sorry, page 57. This is the para 20. Page 57, middle side, middle, my lord. However, Orchid core had faded away. He could not see anything there, my lord. He faded away. So
And
my
on
humble
last
submission-
submission, the medical evidence has also corroborated that the assault part was on the head and it is said that he died of head injuries.
In the main application, but Mr. S. Borwar, the senior counsel, assisted by Mr.
Arsing.
Arsun and counsel. Also heard as Jahan. And some for the state stop. LCRs have been received, isn't it?
No,
LCRs have been received. Please choose director to prepare the paper book. And list the matter of the 4 weeks. In the IA dismissed, we will pass up with all this.
My lord, may I pray early hearing of the matter, man?
Yes. So
Yeah.
Let the paper book be completed.
Paper book. And there is some provision in the High Court rules also, my lord, that may be prepared by the accused side also.
Yes, yes. They can also prepare it, give it for verification. The office will verify and after that, that can also be done.
Then, my lord, the process will be expedited.
So you want to prepare the paper book?
Yeah,
Then you cancel.
that will be verified.
Cancel the order in the manner. Mr. S. Borwar, the senior counsel for the appellants submits that an expeditious hearing is required to be present.
Mahavir koi ka?
Present
Mahavir.
and the book press for preparing the paper book by the appellant.
Within 2 months.
Within
We'll prepare the paper book within 2 months.
2 months. I'm directing the registry to prepare within 4 weeks.
Okay, madam. Okay, madam. I have not heard. I'm obliged, my lord. Obliged, my lord.
Let the registry
My lord, my
prepare in case retain the earlier. order. Or this week, but I mean,
Oh, yeah, so mga bito, kung hindi mo pwede pa naman, ako. Yeah. Upload.
In this case, Lordship, LCR not received, Lordship.
LCS not received.
Lordship, we file our objection.
Let the LCS come.
May I pray for a short date, Lordship? There are two convict, Lordship. One is husband of the deceased, other is mother-in-law of the deceased, Lordship. So I have filed IA for the mother-in-law. So may I pray for a short date, Lordship?
Heard Mr. A. Ahmed
Yeah, Ahmed.
in the main appeal. Council Court Aberdeen also heard MS B. Buyan and the addition to the Assam. Registry is directed, send a reminder, calling for the LCS. List the matter after 3 weeks.
A date may be fixed. He is above 70 years of age, Lordship. Therefore, I am praying as he.
Earlier one was 75 years.
But
are
here,
75,
one judgment
I
of Honorable Apex Court is there, where Lordship,
We're not passing any order.
in IA, Lord,
Main appeal, we're saying to send a reminder. for the
Lord.
Else.
Lord.
5,
Five, I have prepared my objection, but something wrong with the filing. Perhaps we were directed to e-file all the objections. So I may be given some more time and file it. I prepared otherwise. And he has also not got a copy. I have not served him.
My lord, my only thing is that, my lord, this man is in custody since long, my lord, because the trial almost took more than 3 years almost, my lord. They are filing objections for in the meantime, my lord, if the LCR calls for, my lord, I'll argue, because arguing for the IA would tantamount to arguing the entire case, my lord. Because it is an NDPS case, my lord, without any legal evidence, my lord, this man has been convicted, my lord. I'll satisfy your lordship, I'm not on that, my lord. What I'm saying is that, my lord, in the meantime, my lord, because to argue the IA, it would be virtually arguing the entire appeal, my lord. Because I'll have to indicate to your lordship the glaring procedural irregularities.
Then the appeal can be taken up for final hearing.
By final hearing, that is what I was suggesting, my lord. And my lord, most of the deposition are in English. If the lordship gives me liberty, my lord, I will prepare a paper book and I will submit to the court, my lord.
But the lower court records perhaps are not here.
Lower LCS have not come. So let the LCS come.
Absolutely, my lord. So the IA may also come along with them, because, my lord, on 21st, my lord, it would be a redundant exercise without the LCR, my lord. Probably your lordship would also not be able to appreciate my submissions, my lord, without the record.
In the IA, you write, heard Mr. M. Biswas, Learned Counsel for the applicant. Stop MSS Jahan and additional PP, Assam submiss. That she'll be filing her objections within a period of
1 week, filing
1
by tomorrow, day after.
list the matter after 2 weeks. In the main appeal, heard M. Biswas, Learned Counsel for the appellant. Stop. Also heard MS Jahan and additional Assam. Registry is directed to send a reminder calling for the LCS. And list the matter after 2 weeks.
My lord, may I pray for a fixed date on 5th of May, my lord?
5th of May.
5th of May for hearing, my lord.
5th of May is a holiday.
No, 5th of May is 3rd and 4th are holidays. If I go, oh, sorry, I'm looking at 2022.
So what I can say, 5th is a holiday. but
Yes, absolutely 5th is. My lord, 10th of May, my lord, Tuesday, my lord. 9th of May, my lord.
But
By then, everything will be ready, my lord.
by then, I doubt the
I don't
LCR
know
or the
whether
paper book.
LCR will come or not.
Huh.
My lord,
So let us put it 2 weeks, let it
Yes.
come up. Once LCR comes,
no,
Then-
my lord will fix it on 9th. If the LCR does not come, at another date, because, my lord, without a fixed date, it is very difficult to get it listed. Again, we'll have to pursue to the registry, my lord. This is, my lord, we face on 9th, my lord.
in the IA, instead of saying after 2 weeks, say list the matter after on 9th May. So in the main IA also, main appeal, instead of 2 weeks, say list the matter on 9th May.
For hearing, my lord.
Not hearing. Come for orders.
Yes.
For order. Because my lord, I will be arguing the entire,
Doesn't matter.
I'm deeply,
If the LCR comes, we'll.
I'm deeply obliged.
See,
Six, there is a delay of. It's a delay of 35 days. I
Delay.
have no objection to that.
may I please, your lordship. It's an application for condoning the delay of
She has
35
no
days, lordship.
objections.
Oh, yes, yes. Sir.
It's NDPS.
You are Mr.
T Thakuria, lordship. T Thakuria.
Heard Mr. T. Thakuria, then also for the applicants. Also heard MS.S. Jahan, then in addition to the Assam. By this application. The applicant is praying for condonation of 35 days delay in filing the connected application. Stop. MS.S. Jahan, then in addition to the has no objections. Stop. We have also considered the portion, the present value and not satisfied. Accordingly, the delay of 35 days in filing the connected appeal stands condoned. IAS accordingly disposed of. Registry is directed to register the criminal appeal and list the matter and its review process.
Ten of supplementary leave order.
Obliged, lordship.
Supplementary also we have.
We have filer objection.
This petition, you are. Nay, please, your lordship.
Yes.
My lord, this is a 389 petition for suspending of a sentence for a limited duration and to grant me bail for the treatment of my daughter, my lord, who is a blood cancer patient, my lord. I have annexed all those documents. Earlier also, I was allowed to go on bail, my lord. I have already stated, my lord, I can give the list of days for your kind perusal. Before they are right. So, my lord, if your lordship will see, my lord, I have a 13-year-old daughter, my lord, whose name is Priya De, my lord. And I have annexed the certificates, my lord. That is a verified fact, my lord. If your lordship will come from page 18, my lord, annex of 1 series, my lord. Certified that Priya De, daughter of Bipul De, this is the accused appellant before your lordship. Aged about 11 years, female, hospital registration number such is diagnosed as non-Hodgkin's lymphoma and is under treatment in the hospital from 1859 till 2012-23. Her diagnosis is based on FNC report and from Haji Abdul Majid Memorial Hospital Research Center. So this is her blood test report, my lord. So all these medical certificates are given, my lord. And if your lordship will turn to page 21, my lord. Dr. B. Burwa Cancer Institute, case number such, Priya De. At the very early stage, she was diagnosed, my lord, female 9 years. That disease name is also there, diagnosed as PAD Hemlet lymphoma, my lord. So the B. Burwa Cancer Hospital is there. In the meantime, my lord, I'm a life convict, my lord. So I prefer earlier also petitions, my lord. Your lordship will find it at para 16, my lord, of my petition, my lord. And my wife is also 45% disabled person, my lord. So there is none to take care of the daughter, my lord. I being the only male member. I was released on temporary bail for a limited duration, my lord. And I took her to the daughter for better treatment. And also this time also the review is pending, my lord. So for that limited duration, I have paid for 2 months time. so that I can take care of her, my lord, so that I can save my daughter, my lord. So if your lordship will see, I've given a chronological list of days, my lord. Sorry, my junior prepared only one page, my lord. It's two pages. So I've given the list of dates, my lord, from where your lordship will see that earlier also I was granted bail for limited duration so that I could give the better treatment to my daughter. And accordingly, the court was kind enough to grant me bail for limited duration. Once also we have to approach the Supreme Court matter. Yeah, I have stated that also, but and I always used to comply with the court's order, my lord. Hello, my
He's suffering from blood cancer.
yes, my lord. I have stated, I'm given the document. If your lordship will kindly turn to page 12, para 15, my narrations are there, my lord. My contentions are there, my lord. Shall I read for your lordship kind convenience, my lord? That the accused applicant begs to state that his daughter, namely Priya De, now aged about 13 years, is suffering from non-Hodgkin lymphoma, my lord. That is cancer that starts in the white blood cell called lymphocytes and is undergoing treatment at Dr. Bhuvneshwar Borua Cancer Institute, Guwahati. That annexer A1 series I have annexed it, my lord. That the accused, earlier he approached before this honorable High Court for granting ad interim bail for treatment of his minor daughter Priya De by filing interlocutory application being IA Criminal 79 of 21. And the honorable High Court, after hearing the parties by its order dated 24/2/21, allowed the accused applicant to go on bail for a period of 60 days. The accused applicant again filed an interlocutory bail application number IA Criminal for extension of the interim bail order granted to the applicant, and the Honorable High Court, after hearing the parties by order dated 27/4/21, extended the interim bail till 24/5/21. The Honorable High Court by order dated 25/5/21 again extended the interim bail till 25/6. The case was again listed before the Honorable High Court on 25/6, and the High Court, after hearing the parties, further extended the interim bail till 12/7 and directed to surrender the accused before the jail authority, which I did, my lord. Then when the accused applicant was interim bail, he approached before the Honorable Supreme Court by filing an SLP for extension of the ad interim bail by special leave to appeal such, and the Honorable Supreme Court, after hearing the parties on 9, extended the time granted to the accused by the Honorable Guwahati High Court by order dated 25/6 till 16/8 and directed to surrender before the concerned authority on 17/8. Without fail, accordingly, he surrendered before the jail authorities, my lord. Since then, I have not come out on bail, my lord. That is the last time I was out on 17/8/21, my lord. Then, my lord, if your lordship will see my wife's inability also, if a question comes in your lordship mind that isn't the wife capable, my lord, to tackle the situation, then the reply is at para 17, my lord, that the accused applicant begs to that at present his daughter Priya is not keeping well for some day and she is in dire need to consult doctors for treatment. The accused applicant is the only male members in his family, and his wife, namely Amita De, is 45% permanently disabled, orthopedically handicapped since childhood. Therefore, it is difficult for his wife to take their daughter to the doctor or come to Guwahati for treatment of their minor daughter Priya De. I have annexed that annexure 3 also as a proof. And these are also in the earlier record. All these things were taken into consideration earlier, my lord, and accordingly I was granted bail for limited duration. Now this time I am seeking only 3 months limited duration bail, my lord, so that I can bring my daughter to Guwahati, my lord, and give her the best treatment. Once we also took her outside the state also, my lord, and gave her proper treatment, because it is regular checkup, my lord. Otherwise, she might lose her life also, my lord. So that being the compelling circumstance, my lord, I have filed not on the merit of the case, nothing to do with the merit, my lord. That will be taken care at the time of hearing, my lord. There are eyewitnesses also. But fundamental rights are there, my lord, for the better health, my lord. So for limited duration, my lord, and I have gone through their objection, my lord. And put C, my lord, from their objection, my lord. So for the treatment part is concerned, nothing as such has been stated, my lord, only on
Objection,
merit,
when did you file?
I
my
find
lord, they
12,
filed
Your
it, my
Lordship.
lord. Long back, my lord, on 12/4, my lord. 12, sorry. Because everything has been stated from the records, my lord. I'm nothing on the merit of the case at this stage, my lord. Only to ensure my daughter's treatment.
Anyway,
Even
any
12
objection?
for. We have filed 12 for, Your Lordship.
12/4, they filed the objection, my lord,
So
separate.
copy on the other side. Check.
It must normally be in the IA, my lord, I think.
Yeah, it's not there in the IA. No objection. No objection filed.
Lordship.
Has been received.
It's a 5-page objection, my lord. Just to for identification.
No, it says no objection filed on the above listed. Has been received by the council.
They would have flagged it, sir.
Okay.
On the bill.
They have
No.
not received you, no objection.
Lordship, we have on 12 for itself, Lordship.
Maybe, but
We have a copy, my lord, for the court convenience, my lord. My
But
copy.
it should be on record, my lord.
I gave, huh?
my lord.
Or you can give your copy now.
Let us not record, move it for. Lordship, record says status of the Guwahati High Court. 12/4/2023, one document, state of Assam, PP, written objection. There in the record, my lord. I don't know why it happened.
Maybe like.
On record.
The
Maybe it's lying in
the
the. registry.
screenshot says that way, my lord, but practically it may not happen, may not have got been tagged, my lord. That is also there, my lord.
Lordship, but on the system shows, my lord.
System shows that way, my lord.
But here it is not here.
Not on.
The last order is of, order sheet is dated 28/3/2023. It says no objection filed on behalf of state has been received. by the
Lordship,
council.
it came up on 12th, I think.
Hmm.
12 for
After
it
that,
came up.
there's no order.
It's a file good. That very day it was given on the last date of this thing. All thing is said and done for the merit of the case, my
Lordship,
lord.
in merit, they do not have a good
No,
case.
merit, we are not
But
saying anything.
regarding the granting of bail, because his daughter is not well, I leave it to discretion of this honorable court. But whatever document he has submitted, your lordship, it's of 2020.
Right.
Now we are in 2023.
After-
Except a certificate, they do not annex anything, your lordship. To substantiate the grievance that she is having, lordship, it's not a that one day like this one treatment or one day this one, your lordship. Illness. But
My lord-
they did not annex anything apart from 2020 documents, your lordship.
That's true, my lord, because she is a chronic patient, my lord. Nothing has
They would
changed
have
in the
some
meantime.
document to substantiate.
Because
it.
until and
You don't have any recent documents.
I have recent, I don't have it because I cannot come out, my lord, because I have to bring it out to the B. Burwa College Hospital. And if I show it to her in the B. Burwa Hospital in Guwahati, my lord, then only I'll get the recent. That is the issue, my lord. That was the
Lordship,
last checkup we have done.
The
it, my lord.
certificate is given by this one, Bibora Cancer Institute, but along with the certificate, some documents would be there.
No,
On
no,
the basis of which certificate this.
I'll get the
certificate
document
is
only when
issued.
I'll bring the patient before the hospital, my
If
lord.
they could bring and they could annex the certificate of 2023, they could have annexed the other
Certificate of
documents
what,
also,
madam?
my lord.
Certificate of what? I have given the document to show that she is suffering from blood cancer since her 9th birthday, my lord. Now she has become 13 years, my lord. And if I show this time and it is ruled out, I'll be more than happy, my lord, that my daughter has been cured. So if I come with my daughter to the Vibora hospital from Nagaon, Hojai, my lord, and give her the treatment, my lord, doctor will say, my lord, whether she's fine or she needs further treatment or not, because this is a government hospital, my lord. No foul play is there. If anything goes wrong, my lord, then they may recommend for taking her to the outside the state also. We'll go by the doctor's advice. But right now,
Lordship,
I
although
must
it's
bring her to
medical-
the Vibora hospital to get her for the checkup. If the doctors say it is fine, my lord, then I'll go back, my lord, to jail, my lord. But give me some time, my lord, so that I can bring my daughter, place it before the hospital authority of Vibora Cancer Hospital, let them diagnose it. That was the last diagnosis was done.
Lordship,
Now
yes, yes.
now, my lord, the family members have sent messages to me in the jail, my lord. And accordingly, this petition has been filed that she is not keeping well, so she needs some treatment. My lord. For that, for limited duration, if I have asked for 3 months, it may not be granted, my lord, at least 2 months, time may be granted. Or in the meantime, my lord, alternatively, I'll suggest with the lordship permission, let me bring my daughter and place it before the jail authority, hospital authority. And as per their diagnosis, I'll appraise this court, my lord. But give me at least some time, my lord, to bring my daughter to the Vibora Hospital Cancer Institute, my lord. What the doctor says, we also don't know. She may be cured also. She may not be cured also. She may be recommended for further better treatment to Tata Memorial Hospital at Bombay also. That are possibilities. So let us rule out the possibilities, my lord. Just
Well,
because
leave it
he's
to
a
your
life
lordship's
convict, my lord,
discretion.
his personal liberty and right
But
does
your
not get
lordship, if he
extinguished, my
could
lord.
not substantiate his claim, your lordship, regarding the, because he could not annex anything.
No, I cannot annex it because I do not have any document and I would not like to annex the fixed documents, my lord. Because there is none to bring her to the hospital, my lord. Mr. Bhunia appears for the informant, my lord.
And for the informant, my lord, the victim family wherein my family members has been subject to brutality, my lord, wherein they have been convicted. Now, on this, after this appeal has been preferred, my lord, an application for bail was moved. It was rejected. Now, subsequently thereto, as for records, my lord, I am stating, my lord, they filed this petition IA for granting 2 months' time at the inception. And that's been reflected in paragraph 16 of this particular petition. Now, my lord will kindly see. On the first occasion, when for the treatment of the child, being the informant, and on the instruction of my client, I didn't object to it. Let it be granted. That was my plea before the court. And the Honorable Court allowed it for 2 months. The order dated is 24/2/2021. After 2 months, they didn't appear. They didn't surrender. They come on extending it. And the last occasion when this Honorable Court dismisses their extension, this one, that you have to surrender by this date. Now they went to the Supreme Court. And the Supreme Court order has been there. And it's been finality wherein a date has been fixed that you have to surrender. They surrendered. Now, when they surrendered, my lord, they sought for 2 months' time. And they ultimately, order was 24/2/2021. Ultimately, they surrendered on 16/8/2021. 17/8/2021, my lord. After 6 months, 2 months was given, my lord. 4 months was taken in extension. Now, from the records, my lord, that plea was that she has to be taken to Kolkata. Now, my lord, see any document with regard to treatment at Kolkata? Absolutely no. Because this is a plea wherein coming to the house, his house, wherein this informant family also resides and terrorized. So this has been a modus that has been operated. On the first occasion, we didn't object to it, showing that treatment of a child is very much necessary because human life is more precious than anything else. But see their modus, my lord. 2 months' time and then extended another 6 months. And today also they've preferred a petition on the basis of which, what document they are annexing it? 2020 document, my lord. Some document has to be there. On the pretext that 2 months required will be required, my lord, for the treatment, for her treatment, a statement will not do. some document, prima facie document to satisfy this honorable court that yes, these are the documents required, and for that purpose, he being the father of the child, his attendance is required. Nothing is there. These are the documents with regard to 2020, prior to passing of the order, my lord. And on the last, when they sought extension, it was taking to Kolkata. There is no document that they have taken to Calcutta, my lord. So on this pretext, my lord, wherein the jail manual itself provides for such kind of release, my lord, itself, it's furloughed. There is no petition. Why the court will enter into that particular jurisdiction wherein specific statute has been made for that purpose, wherein a person concerned can apply for furlough. And that furlough period would be counted for remission, if any at all, if at all he is been entitled to. Now, on one occasion they came in before this, we did not object, sir. We honorably submitted, and it's been reflected in the order itself, first order, that it's not been objected and fairly submitted. But on the pretext of fairness, this cannot be a modus to come out and terrorize my clients, my lord. I oppose these bail applications, my lord. And my lord, they have annexed B. Borua Cancer Institute. This is in Nagaon, my lord. They're from Nagaon. This is here. There are wife and husband. There are other family members also. For a treatment, my lord, to bring the child to B. Borua Cancer, where the treatment is free of cost. Latest machinery has been fitted in.
Let me bring.
And my lord, Tata Memorial Hospital has been now for cancer patient for Northeast. All specialized machine. Everything can be done. Why he's released? So that under the pretext of the treatment of the girl child, he can enjoy free life. That's all, my lord. My objection is to that extent.
My lord, I have to bring her to Guwahati or Tata, wherever
Mr.
it is.
Kumar,
Yes, my lord.
we have considered the submissions of all the parties.
Yes, my lord.
We have the opinion that you should produce some reports,
Yes.
documents.
Well,
Some
I'll try,
letters.
my lord. Because actually, my lord, until and
So
after.
at least one in the earlier instance,
Yes, ma'am.
you said you're taking her to.
I'm proposing to bring her to Guwahati from
So-
Jai, my lord.
It is not a condition that you don't have any other relatives.
Absolutely. Till now, my lord.
Let them bring her.
Absolutely.
We are not dismissing your
Right.
IA at this stage.
My lord, my lord.
We'll give you a time
Time. my lord.
to produce some fresh documents.
Yes, ma'am.
Or latest documents.
Sure, sure. I
After
get
that,
your
we
lordship.
consider your IA.
My
We-
lord.
We are
I'll
not
try to get-
dismissing your IA.
Sure, my lord. Because without producing the girl, nobody will give a certificate, my lord. That's true, my lord. But now to bring the girl is the biggest problem. So 2 weeks time may be kindly granted, my lord.
2 weeks time.
Right.
Heard Mr. Z comment and the senior counsel. Yeah. Also heard Mr. MS.B. Buyan, the additional PP, Assam, and Mr. AK Buyan.
AK Bhuiya, my lord, for the informant
For the.
and B Bhuiya for the state.
Mr. Z. Kamal and the senior counsel for the applicant is directed to produce fresh documents with regard to the illness of the daughter of the
Right.
applicant.
Right. After that, the prayer
This-
can be,
this
will be considered.
after-
Deeply obliged.
My lord, kindly a date may be given, my lord. Otherwise, my lord, 2 weeks, my lord, any date. my lord.
Leave it to the court.
Are you sure you can do it within 2 weeks?
Oh, my lord, yes, my lord. Date if given, my lord, then it's urgency is there, my lord. Say in the first week of
8 May.
my lord, can it be on night, my lord? 8, I'll be out of station, my lord. 9,
9.
9. Much of
9, I won't be there, my lord. I'll be out of station any other date, my lord. Apna convenience.
How about 10th?
Then I'll be out of station. my- Let it be on 11th, my lord.
All criminal lawyers,
11,
my lord,
11.
we are moving around the state, my lord, and the northeast state.
11th?
11, my lord, will do.
11th May.
11 or 12, my lord, or anything.
Any day.
Let it be on 12, my lord. It will be all for all continuing.
Okay.
12, my lord. My lord.
12, 12,
My problem.
Deeply offline.
Say fresh medical documents with regard to the illness of the.
Item number 7 of daily list, hearing.
1 minute. We'll resume after 10 minutes.
The council is not here in item number 7.
Anyway, 10 minutes.
Lord.
We'll just come back.
Lord.
Oh. Oh, I didn't know this. Okay. Go on. You take your time.
Item number 7, this Miss Korobi Saikia is not here today. Otherwise,
Saikia.
cases father killed the mother and the children had turned hostile, one daughter. Others have not seen. A very bad case for the prosecution, but
She's not appearing.
and the conviction was granted on the ground that it cannot happen. I mean, the whatever the daughter is saying is not believable. In that time, it has to be the father who had killed the mother, and then the presumption, in fact, it was taken. I'll have to go deeper into the matter. Otherwise, it's the bad case for the prosecutor.
Okay.
Miss
Done
Korobi
the
Saikia
case.
actually is not regular at all. Miss Korobi Saikia is not regular at all. She, I think, on the last occasion also she didn't turn up.
Hmm. Let us take one more chance.
Not-
After that, we'll appoint or do you want,
No, Lordship. I'll inform her if I
let
get
us give her
somewhere.
one chance.
Hmm.
Then the amicus curiae is absent. MSS Jahan and additional PP appears on behalf of the state of Assam. List the matter again after 1 week.
Obliged.